Good morning. Please be seated. We are here for oral argument in cause number TX180001, ROI et al. Versus Ford et al. These proceedings are being video and audio recorded, so we ask counsel to please identify yourself and your client at the beginning of your argument. Each side will have 20 minutes. Appellant's counsel is responsible for watching the clock to reserve a portion of that time for rebuttal if desired. We have read the briefs, we have conferenced the case, and we are familiar with your arguments. At this point, counsel, you may proceed.
Good morning. Please the court, Bradley Pack appearing on behalf of Appellant Compass Bank. With me as well at counsel table is Stuart Rogers. Mr. Rogers is the attorney for ROI Properties, which was the receiver for Lew's Social Services. Your Honors, in preparing for this argument today, it quickly became apparent to me how awkward it is to have to keep referring to two statutes whose citations sound so similar, ARS 42-11004 and ARS 42-11104. So with the court's indulgence, I'd like to just start by defining some terms. I'm going to refer to the first statute, ARS section 42-11004, as a general statute, and ARS 42-11104 as the specific statute. And I think that nomenclature is appropriate because, just like it sounds, the general statute really just serves as a default rule that's applied to judicial actions for a refund of taxes when there is no more specific statute that is directly on point. The specific statute that's at issue here is a very specific statute that applies in a limited number of circumstances to out-of-court, non-judicial determinations, and it serves a very specific policy purpose. The purpose is to incentivize charter schools to operate in Arizona by relieving them of the burden of paying property taxes. The policy that that statute reflects is so strong, in fact, that it gives charter school operators a second chance to obtain a property tax exemption, even if they fail to timely file the affidavit of eligibility that otherwise would be required to maintain the benefits of that exempt status. What's more, the statute grants charter school operators an unlimited amount of time to obtain forgiveness of not just the principal amount of taxes that were assessed, but also interest and penalties that would not have accrued unless the taxes were delinquent. And after the taxes are paid, it gives the taxpayer a year to file a petition for a refund of those taxes, regardless of whether they were paid prior to becoming delinquent. The tax court in this case erred in dismissing a complaint that sought to vindicate the rights under that specific statute based upon the application of the general default rule to this case. The court erred for at least four reasons. First, the two statutes that are at issue are not statutes on the same subject, as the county defendants acknowledged in their own brief. Second, as this court held in Strawberry Ridge, the general statute is a general statute that must yield to more specific statutes that prescribe different time requirements and do not require taxes to be paid prior to delinquency as a condition to obtaining relief, as is the case with the specific statute in this case. Third, in addition to Arizona law, federal bankruptcy law precludes the enforcement of a statute that requires payment of taxes prior to delinquency at a time when the debtor is in an active bankruptcy proceeding as a condition to obtaining tax relief. And fourth, in addition to being entitled to relief under the specific statute, the plaintiffs in this case were also entitled to relief under ARS section 42-18-352, and the tax court erred in either not construing the complaint as stating a claim under that statute or in dismissing the complaint outright without granting leave to amend the complaint to specifically identify a claim under that statute. Your Honors, I can appreciate that the court has read the briefs and has discussed this in conference and is likely very familiar with the facts, But I do want to highlight some of the key facts.
Before you do,
Sure.
I want to make sure you have time to address, in particular, why the property didn't lose its exempt status when the school ceased operations. And why wouldn't that be a basis for affirming the decision below?
Well, Your Honor, there's nothing in the statute that says that a charter school loses its exempt status for the entire year when it ceases to operate as a charter school for a portion of that year. Here, you've got a charter school that was in operation as of the beginning of the year and actually operated through May 29th, through the close of their 2014 to 2015 academic year. And the purpose, again, of the statute is really to incentivize charter schools to operate in Arizona. So when they do that, when they choose to operate here, they do so knowing that they're going to receive an exemption from paying property taxes.
So if they're in operation for a month, they get the benefit the entire year the property is exempt?
Your Honor, I believe that would actually be the case, although I think it would be a very, very rare circumstance indeed where you do only have a charter school that operates for such a limited period of time. And under the facts of this case, you actually had a charter school that was in operation for over 14 years before it finally had to
14
close.
years doesn't have anything to do with the tax year. And how do you distinguish the Hub Property Trust case?
Well, Hub Properties was a case that dealt with a government tax exemption. The government never has to pay taxes on its own property. In contrast, charter school operators only have an exemption by virtue of the fact that they're operating a nonprofit school for educational purposes on their property. When you purchase property from the government, you shouldn't have any reasonable expectation that you're going to receive a property tax exemption for the entire year, because if you're using it for your own commercial purposes, there's no reason to grant you that exemption.
Why is that different here? The purchaser, in this case, wasn't intending to use the property for charter school purposes. Why wouldn't the logic of Hub Properties apply here?
Well, first, Your Honor, I'm not sure that the purchaser didn't intend to use the property as a charter school. I'm not sure there's any evidence on that issue.
But certainly if they had, they could have said that, and they presumably would have qualified. The property would have qualified. Would it not have? If it had been used by the previous owner, it's a charter school, somebody purchases it to use it as a charter school, wouldn't all the boxes be checked off that would entitle the property to be treated to give that exemption?
Ultimately, yes. If the new owner comes in and purchases the property and begins to use it as a charter school, then yes, they could obtain an exemption as well. But to address the court-specific question, what's different here, and I think the purpose of the statute is not going to be served if charter schools are going to be at risk of having their tax-exempt status retroactively revoked to the first of the year, simply because they're not operating at a particular, they're not operating as a charter school at a particular point in time. It's also not clear when you're going to establish that cutoff. The county defendants want to make that cutoff date the 3rd August of the tax year, but doing so doesn't really make sense. And you're saying, unless you're fortuitously happen to be operating and not on a teacher's day and not on spring break and not on anything else, on that 3rd August.
I don't think on break it seems a bit different. You're still operating a school when you have a spring break. I don't think anyone would expect that you would lose your status simply by having routine spring break or fall break or whatever it was.
Or even summer recess.
Right, and it understood, Your Honor, but I think the significant issue here is that charter schools need to be assured that they are going to have a tax exemption for the full year when they are operating here.
But they're selling the property. I mean, yeah, they have an exemption, and they had an exemption for as long as they were operating the property, but they're now selling it. I mean, I know it's different here, but that's the argument, is they're selling it.
Well,
Why should we give them, why should they sell it for profit if they can sell it? Because it's worth a lot more money if they're selling it and there's not a tax liability on the property, right?
I don't think it's worth more money necessarily. I think that they may retain more of the proceeds. But I think the facts of this case actually illustrate exactly why it's appropriate to retain that tax exemption for the entire year. Lew's Social Services didn't just spontaneously make the decision that they're going to cease operating as a school. They found themselves in a situation where their founder had died. They were in very dire financial condition. And this is a school that served an underserved population in a poor area of Tucson that found themselves cash-strapped and unable to meet their financial needs. They filed bankruptcy, not because they wanted to, not because they were trying to sell the property at a profit, but because they had no other choice. And if you're going to tell charter schools, listen, if you find yourself in a bad financial condition, if you find yourself cash-strapped and unable to pay your expenses, not only are you going to be forced to make some difficult financial decisions and potentially file bankruptcy and put your future at risk, but if you do stop operating, we're going to hit you with a double whammy, which is we're going to retroactively revoke the tax-exempt status that you should have been entitled to as of the first of the tax year.
But aren't we, instead, wouldn't we just be saying, you're only entitled to this exemption, you get to pay less than everybody else if you're actually using the property as a charter school for the entire period. If you're not going to get this benefit. We're going to treat you like everybody else. So I'm not sure that there's any inherent unfairness in if that's the rule up front, you only get this exemption if the property is used for the year. It may be unfortunate, but an exemption is a benefit that you're getting, and can't the state come in and say we're only going to give you that benefit as long as you check off all the boxes? And here they haven't checked off all the boxes.
Well, Your Honor, first, there's nothing in the statute that would indicate that is the case. So a charter school operator that goes into the school year, or goes into the beginning of the year thinking that they are going to be tax exempt because they get their exemption on March 1st, they do everything else they're supposed to do, and then they find themselves in a situation by the end of the year where they have to close down, they wouldn't have any expectation. It wouldn't be fair to them to say, oh no, you're going to lose your tax exempt status now, because there's nothing in the law that would put them on notice that they're at risk of losing that exempt status. What the statute says is actually to the contrary. It says that if you operate a charter school, your tax exempt status begins from the first day on which you acquire that property. Not the first day on which you start operating as a charter school, but upon your acquisition of the property.
But you have to let the state know if you cease operating as a charter school, do you not?
You do, and what that triggers, Your Honor, is it triggers your obligation to begin filing affidavits of eligibility again as of the start of the next year. So when you obtain your exemption initially as a tax-exempt charter school, you have to check all the boxes and go through the process for the first year. After that, you're not supposed to be required to file affidavits for every succeeding year.
You go 5 days into the next year, and then you just stop. You're entitled to the exemption for the full year, in your view?
Frankly, in my view, yes, but I don't think that you need to go that far in order to reverse the tax court's decision in this case, where you have a school that did operate for an entire school semester all the way through May 29th. And, as an alternative, I think at the very least what they should be entitled to is a prorated tax exemption for at least the portion of the year in which they operated.
That. Is there anything, any case law, any statute, anything that says you can prorate the tax burden? That split, once you lose, I mean, you talked about the inception, when you actually acquire the property, when you're divested of ownership in the property. Is there anything that would authorize us to prorate the taxes?
Frankly, Your Honor, I haven't found it in the case law, and believe me, I've certainly looked. But what I also haven't found is any law to the contrary that says You stop operating as a charter school before the year is completed, before December 31st, you lose your exemption. What I also found...
Isn't that going back to what Judge Catani asked about the hub case? I mean, isn't that pretty much as close as we get?
I think the hub case actually said the exact opposite. What the court said in the hub case is that the property was exempt for the portion of the year in which it was owned by the state. So there you have a case where property is exempt for
So that
part
would
of
be
the year.
support for your prorated, is that if it was exempt for a part of the year, and then it would be taxed at the balance of the year?
I think that could provide support for that, Your Honor. Yes, although the court didn't do that in that case because it wouldn't have to. The state never had to pay taxes anyway, so it didn't have to ask for any type of proration. I do think that's supportive of the idea that you can prorate the taxes for a portion of the year. I do quickly, I see I'm running out of time, and I want to address one issue about the legislative history of the statute. And we included in the appendix to our reply brief a copy of the the Senate fact sheet for ARS 4211-104 when it was initially enacted. And what the fact sheet says is that when a property qualifies as a tax-exempt charter school, it obtains that exemption for the entire tax year, which is, of course, our argument. So there is nothing in the statute that would retroactively revoke the exemption.
Is there any indication that even if it gets it for the entire tax year, even if it stops being a school after 1 month?
I haven't seen that specific indication in the text of the statute or in the legislative history. But again, I would distinguish it from the actual facts of this case and what we've alleged in the complaint, where you have a charter school that not only operated for 14 and a half years before it closed due to financial conditions that were...
Not buying 14 and a half years, but 5 months is what you're suggesting.
5 months of the 2015 tax year until it couldn't operate any longer because it didn't have the money to do so. And Your Honors, I'm down to about 3 minutes and 30 seconds, so unless the court has any additional questions, I'd like to reserve the remainder of my time.
Thank you.
Good morning, and may it please the court. My name is Andy Flagg. I represent the county defendants in this matter. I'm going to start by addressing the issue of whether the school lost its exemption when it ceased operation in May. I don't think there's anything special about government ownership with respect to the hub case. I think the lesson of the hub case is that as of the levy date, which is the third Monday in August, the property was not exempt, and so the fact that it was in government ownership for part of the year doesn't change that fact. And I think that principle will apply to any tax exemption. I don't think that the government tax exemption is anything special. Likewise, I think Mr. Pack's argument, if accepted, would apply to any property tax exemption. There's nothing special about the charter school statute. Mr. Pack's argument that, so long as the exemption is, or the use is in place for part of the year, even if it's 1 month, I don't know any reason that wouldn't apply to any other tax exemption. So I think based on the hub case, as of the date of the levy in the third Monday in August, if the property is no longer exempt for whatever reason, whether it's because of government ownership, because of use as a religious institution or a charter school or whatever, it's not exempt. And so for that reason, as I think Judge Catani, one of Judge Catani's questions suggested, I think that is an alternative basis to uphold the trial court's ruling in this case.
Why wouldn't you prorate it in that situation?
Because I think as the colloquy between Judge Campbell and Mr. Pack suggested, there's no authority that either in statute, case law, anything that I've been able to find, and Mr. Pack conceded there's nothing he's been able to find that permits proration of real property tax.
Common sense, we can't rely on that in this.
Well, I will say
Wouldn't that be fair to say it was used as a school for 5/12 of the year?
Well, it's a different context, but I guess what I would respond to is the Church of Isaiah case, and there's other cases I think that suggest this too, is that real property taxes are heavily governed by a set of statutes, and a court's sense of fairness about what might apply in a particular case. That doesn't really govern. It's heavily governed by statute. I think if the legislature wanted to authorized proration of taxes, it certainly could do that.
If we look at it in reverse and you take ownership August 1st, you're entitled to the previous year tax exemption if you're operating as a charter school, is that correct?
Well, I suppose they wouldn't meet the time frame to submit the affidavit, but I guess the idea is because that's the date they took ownership, they become exempt. I'm not sure I know the answer to that question, but certainly there would be a better argument. There would be an argument that the property would be exempt because as of the third.
Let's say they take possession on March 1st. Do they get 3 months
Well, again, I think
exemption?
I think what Hub suggests to me is that the tax exemption is determined as of the levy date. So again, that if what Your Honor's question is suggesting is that the charter school takes ownership March 1st and therefore and owns it and uses it as a charter school for the remainder of the year, I think there'd be a strong argument that it would be exempt for the entire tax year.
What if the charter school sends their notice that they're through, and it's 11 months into the tax year? You're not going to take away their tax exempt status for those. I mean, they've been there for 11 months, right?
So in November of the tax year, yeah. Well, at that point, the taxes have already been levied for that tax year. So that again,
So it's just the levy date. So as long as you're operating as a school up until the levy date, anything after that, if somebody else buys the property after that, they just get a freebie.
I think that's certainly what Hub suggests, and I would also suggest that that's the way the scheme has been administered throughout the state. This isn't the only time I think that a property goes from exempt to non-exempt or non-exempt to exempt at some point during a tax year.
Going to Judge Campbell's question, though, if they buy the property, the charter school buys the property in June, that it doesn't statute provide that they only get the exemption moving forward? Or are you saying if they tick the box in whatever the levy date is, they get it for the entire year? Well, presumably someone else when they buy it, someone else already paid the taxes when the purchase. I'm not really sure how it works out with the.
And I don't want to misunderstand and mislead the court. I'd have to go back and take a close look at the statute and how it applies if we're talking about the year in which the charter school acquires the property and how the exemption would apply there. I just don't want to incorrectly answer that question. That's obviously not our factual scenario. We have the reverse. So I'd be happy, if the court wants a supplemental brief on that or something, I'd be happy to do that. I just don't want to incorrectly answer that question. I'm not really prepared to answer it.
Well, just looking at equities, if you get the benefit of it here, you get the detriment of it here, that seems a bit more fair. That's why I asked the question.
Sure, and again, I guess my answer to that would be that the scheme is administered by the statutes, and anybody's sense of fairness in a particular case doesn't necessarily govern. I guess that would be my answer to that question. I would like to get to the issues that the trial court raised in support of its ruling, and that's specifically the applicability of 42-11004 and then the bankruptcy. And with respect to the first issue, just as we talked about with the administration of the tax scheme overall, it's the legislature's province to establish the procedures under which a property owner establishes an exemption and under which a property owner can go to court to litigate the validity of a tax for any particular reason. And it has set up a general ticket into court, which is 11004, which says if you want to challenge the validity or amount of tax, you have to pay it before it becomes delinquent. And what the Strawberry Ridge case tells us about that statute is that's the general procedure for getting into court. If the legislature sets forth another procedure to get into court, then that specific statute is going to govern. And that, in that case,
even if there's a bankruptcy and there's a stay in the bankruptcy, that you necessarily have to satisfy that prong?
Well, Your Honor, I think when you get into bankruptcy, you get into questions of federal preemption and that sort of thing. I'm happy to go into the bankruptcy issue if Your Honor would like. Basically, in this case, you have a post-petition claim, so that's not subject to the automatic stay. The lien for property taxes is not subject to the automatic stay. The only action that the county defendants took that could arguably fall under the automatic stay as an action to control property of the bankruptcy estate would be the motion to dismiss filed in this case. that would be arguably the action that could constitute interference with or a violation of the automatic stay. But that action was taken 6 months after the bankruptcy court had already confirmed that any claim for a refund of property taxes was abandoned from the bankruptcy estate. So at that point, the automatic stay didn't apply to any claim for refund of taxes. So I guess it's a long answer to your Honor's question. The answer is no. If the bankruptcy stays in place and an action would constitute violation of the bankruptcy stay, then it's going to be governed by federal law. But in this case, on these particular facts, the bankruptcy stay was no impediment to the county filing the motion to dismiss that it filed below. But under state law, if you have, and what the Strawberry Ridge case says is if the legislature has established a route into court that has different rules than under 11004, then those rules apply, and that was 48-1835 or 42-18352, in which the court said if you pay the tax, you can go to court. Well, the statute that Mr. Pack is arguing his ticket into court here is 11104G, which has no provision for judicial review at all. It simply says you can go to the board, you can ask for relief from the Board of Supervisors of a failure to timely file the affidavit you're supposed to file by statute, but there's no provision like there is in 42-18352 that says, and if you don't like what the board does, you can go to court so long as you pay the tax or so long as whatever conditions the legislature wants to impose. So Mr. Pack's position is basically that the legislature silently overrode the general rule that you have to timely pay your taxes to go to court when it enacted this provision for Board of Supervisors review of the timeliness requirement. There's nothing in Strawberry Ridge or in any of the other case law from this court that says that sort of...
Does Strawberry Ridge requires a timely payment?
No, Strawberry Ridge requires payment. And it's not Strawberry Ridge that requires payment, it's the statute that requires payment. And the court in Strawberry Ridge says...
But here there has been payment. They did make the payment. It was late.
Right, and the difference here is there's no statute that applies that says if you pay the tax, you get to go to court. And I think that's probably why Mr. Pack wants to raise the alternative argument that he can get into court under the Treasurer Review statute, the abatement statute 42-18352. But as we pointed out in the briefing, that was not what was filed with, there was no petition filed with the treasurer that qualified under that statute. And so the procedures to get into court under that statute weren't followed here. So the argument is it's because there's this review or this basically legislative grace under which the Board of Supervisors can forgive the timeliness requirement. And there's no provision in statute for judicial review of that. But the argument is that under that statute, then you get to go to court irrespective of whether you paid the taxes timely or, frankly, whether you paid them at all. And that's inconsistent with this court's case law interpreting the statutory scheme altogether and specifically interpreting 42-11004. I'm happy to answer any additional questions that the court has. I don't think I have anything additional that I need to say.
I've got just one, and it's, they cease operation in May. We all know there's summer break. Had they come back and geared up to start school again, and on the date they levied taxes, there were no children there, but they were gearing up, they're entitled to the exemption for the entire year.
I mean, I suppose it would depend on what constitutes use as a charter school, but I think if they were gearing up and getting ready to allow students, and then they later did in the year, it would certainly seem to me that would be operation as a charter school.
What if their typical summer break was from the May date until September 1st? So they would have been on summer break during the levy date. Hadn't decided if they're going to open or not. What do you think then?
Well, I think that the school has to operate as a charter school in line with state law. I don't know whether a school can wait until December or till September, to decide whether they're going to operate for the fall or not. I'm not a charter school expert. I'm not a school law expert. I guess my answer to Your Honor's question would be, assuming that's permissible as the use of a charter school, I think absolutely they'd be entitled to the exemption if they were going to continue to operate throughout the year. In this case, the school ceased to operate at the end of the spring semester, and at that point had an obligation under the tax statutes to notify the assessor that they had ceased operation, because it's the use as a charter school that gives it the tax exemption. Thank you.
Counsel.
Your Honor, there's a lot of things that I would like to address, and I think my bankruptcy colleagues would be especially upset if I didn't address the bankruptcy issues. But frankly, I can see where the court's concern is, and that's obviously with the issue of proration or operation throughout the entire year. So that's what I want to focus on, and I'll get to the other issues if I have any time left. When you look at the policy behind ARS Section 4211-104, which really is to incentivize charter schools to operate and to give them a tax exemption, I think there is no way that you can serve that policy unless charter schools are given a tax exemption, if not for the entire year, even if they've operated as a school for part of it, then at least for the portion of the year in which they have done everything that they need to do in order to qualify for that exemption. Otherwise, it's simply undermining the policy concept and the specific tax exemption that charter schools were granted, to say, you don't operate for all of the year, you get the exemption for none of it. To do that would be to upset not just the financial planning and projections of the charter schools, but also, as you can see in this case, their lenders and the other people who are relying on that exemption when they make decisions about whether to fund charter schools, whether to open charter schools, how they're going to be financed, whether bonds are going to be sold to finance the operation of the charter school. When you introduce this serious uncertainty about the possibility of retroactively revoking an exemption, even for
But whether to lend isn't really going to change whether they're going to be repaid. They go out of business. Yeah, you're saying there would be more money to pay the lenders if they don't owe these taxes, but presumably the taxes we're talking about for the whole year, the purchaser of the property is paying, and they're kind of unrelated to the prior lender.
I mean, I don't think that's actually the way it works in practice, that the purchaser pays the taxes. They certainly don't pay it for the entire year. Usually taxes are prorated at whatever portion of the year the purchaser gets the property. The seller pays the portion of the taxes for the year up until the part of the year up until the property is sold, and then the buyer takes on the burden of paying the taxes for the remaining year. I think the treatment of those taxes should be reflective, at least, of the practical realities in the way that these transactions actually work. And that is, if you are going to operate as a charter school, you're going to do everything that you need to do in order to get this tax exemption. You should, at the very least, be entitled to the benefits of that exemption for the part of the year in which you are doing what you were required to do by the statute to get that exemption, and operating as a nonprofit charter school like Luz was doing in this case. And to use, first of all, HUB didn't establish August, some date in August, as the magic date for determining whether exemptions apply. It just didn't. What the court in HUB was talking about was they were essentially responding to an argument made by the plaintiff in that case, where he said, well, we were exempt for the entire assessment process. And the court said, no, that's not really true. The assessment process starts back in January 1st of the year before. It continues on when the tax lien attaches in January 1st of that year, and it keeps going on until the taxes are actually levied. The court didn't say that date in August is a magic date for determining whether exemptions apply, and if it did, I think that would be establishing a plainly arbitrary rule, which would, for example, entitle charter schools to operate one day out of the year and get the exemption for the whole year, which could not have been what the legislature intended either. Your Honors, I am out of time. Unless the court has any further questions, then I will sit down.
All right. Thank you. And we thank you both for your arguments. This matter will be taken under advisement, and we will produce a written decision in due course. We are at recess.